Hi everybody, today we're going to talk about how I saved a client over $100,000 even after he forgot to send his notice to owner. Let's get started. Hi everybody, my name is Alex Barthet. I am a board certified construction lawyer, and today I'm going to tell you a story about a client of ours who thought he lost $100,000, but only after he came to us did he realize that he fell into a very narrow exception in the lien law that allowed him to recover even though he didn't send some of the notices that he thought he needed to. So let me tell you the story. When he comes to us, he tells us he's a subcontractor on a public project down in Homestead, and he forgot to send his notice to owner. Normally, that would be the beginning and end of the analysis, but we dug further. And what we learned is that this contractor failed to record a copy of the bond. This is a requirement in order for the notice to owner, or in this case specifically notice to contractor, the notice to contractor time to start running. As you know, normally you have to send this notice to owner or notice to contractor within 45 days of your first work on the job. There are many exceptions to this rule, and this is one of them. So as a subcontractor, he would normally have had to have sent this first notice, this preliminary notice, but he didn't. But because the general contractor didn't record the bond, the time didn't even start to run. So by the time the client came to us, he was already off the job. It had been about 60 days since he finished his work. When we realized this mistake existed, we immediately sent a notice to contractor / notice to owner, the first notice. Now meanwhile, this is almost a year after he actually started work. The next day, we sent in the notice of non-payment. That's the next document that's required. That's the claim on the payment bond that triggers the obligation of the surety. And then the third day, we decided to file a lawsuit immediately. Now, once we filed this lawsuit, we were met with a claim by the other side that we didn't timely send the first notice. But what we did is we proved to the other attorney and the contractor and the surety that because they failed to record a copy of the bond, their own bond, that my 45 days didn't even start to run. So what's the moral of the story? The moral is, because the lien law is so complicated, just because you think you missed a deadline or that you didn't follow a rule, don't give up. There are many exceptions to the rule. There are even exceptions to the exceptions. And until you verify that there's absolutely no avenue of recovery, you shouldn't give up. If you have any questions about this issue or any others, check out thelienzone.com. Always follow us on social media @thelienzone. This is Alex Barthet. See you next time.